that only the presence of a judiciary will make matters transparent. That is impermissible. Constitutionally impermissible.
I have not.
Such a contention was.
I have not argued that only the presence of the judiciary. I have said that they need
that.
Yes, I understand.
That is because we can't reduce our Chief Justice to be somebody who goes there and makes a recommendation which at the hands of the Council of Ministers will die a premature death. Not a case where there is a vacuum which has produced a corresponding infringement on a fundamental right, which again in turn is a question which we'll have to ask ourselves whether there is a fundamental right.
Yes.
Because you have to link all this together.
Yes, Lord. That's what I'm trying to answer.
Whether there is a vacuum.
Yes. So
Also, you missed out one important contention by the Solicitor General.
yes.
Contended the belief that, or that is crept in, that only the presence of a judiciary will make matters transparent. That is impermissible. Constitutionally impermissible.
I have not.
Such a contention was.
I have not argued that only the presence of the judiciary. I have said that there needs to be a neutral and an independent body to select election commissioners. And the fact that there is no neutral or independent body may lead to and has led to selection of election commissioners who may not be and often have not been independent. I arguments delve into the question as to why there is reason. Now, this trigger point argument, if there has been no trigger point, etc. In the petition of the Association for Democratic Reforms, which was filed in 2021, my lord, we have not only annexed the report of the Citizens Committee, which details at great length at least 50 instances of the Election Commission not behaving independently. I didn't want to go into that because I thought it was not necessary for me to go into that. The reports, why are the Law Commission, Goswami Commission, it is said, it was argued by the Attorney General that, look, they have not gone into this matter at great length. They have not first said that the Election Commission is not behaving independently, therefore we need to put in place an independent mechanism. Or that in the absence of an independent mechanism, Election Commission will not be independent. Of course, the Citizens Committee has said so explicitly. They have said so explicitly, repeatedly. Here are the instances of the Election Commission not behaving independently. And this is why they do not behave independently, because the appointments are completely. Of course, they recognize that the Election Commission has functional independence in the sense that the government has no disciplinary power over them. But they say that it is happening because the government has complete and unilateral control over the method of appointment, and the partisan behavior of the Election Commission is writ large to see. And therefore, my lord, for us to believe that Law Commission, Administrative Reforms Commission, Goswami Commission, National Commission to review the working of all of them would make this recommendation in the air, in the absence of their not realizing or feeling on the basis of the evidence that was before them that, look, Election Commission's independence is questionable if the appointments continue to remain unilaterally in the hands of the government. As my lord, somebody said that though it is good to keep our minds open, but not so open that our brains fall out. So, I mean, one can go on saying that, look, there is no trigger point, there is no reason to believe why the Election Commission will not behave independently, there is no material to suggest that the Election Commission has. I could go into that, I could spend a lot of your lordship's time. Citizens Commission has gone, Citizens Committee has gone into it, headed by Justice Lokur at great length, pointed out large number of instances. But I thought that it was not necessary to get into that because there is judicial recognition of the fact in the judge's appointment case judges appointment case also, the court did not go into the material to show why the appointment by the government alone or the selection of judges by the government alone is leading to non-independent judges. They said it's given. They said this is axiomatic that if the selection remains in the hands of the government, it will lead to a great danger to the independence of the judiciary because it will lead to selection of not independent judges.
There are two questions here.
Yes.
We'll have to both Gopal, will also listen and they can answer. One of the contention was that if the Chief Justice is made a party,
Yes.
is a member of the collegium, or
Yes.
so-called collegium.
Yes.
Now, you can't, you also agree that the president will continue to be the person who will issue the order of appointment.
Yes, of course.
Now, under the constitution, president means the council of ministers. Now, a three-member collegium, as we put it, the prime minister, leader of the opposition, and let's say the chief justice, as recommended by the. What will be their exact role? Will their role be that they have a panel and they recommend somebody? Then what is the role of the council of ministers? Unless we say that the council of ministers is to be eclipsed completely, in which case it will actually incur the wrath of Article 74 and the whole core of the constitution being based on, council of ministers advising the president. A third party like a collegium, which you are suggesting.
But that is.
We are concerned with that.
Yes, I understand.
That is because we can't reduce our chief justice to be somebody who goes there and makes a recommendation which at the hands of the council of ministers will die a premature death. If the chief justice goes in keeping with the prestige of the office of the chief justice, it should carry enough weight that it should finally mature into an order of appointment being issued by the president. Otherwise, we'll be lowering.
No, that's
dignity
true.
of our president.
That's the order. The order of appointment is also made by the president.
There's no constitution. There's not. Provision is
That is relevant. I respect that.
But that's to the council of ministers. You tell us what is to be done with the council. Does
Yes.
it have to, under the
Yes, yes.
rules of business, do we then say, supposing this is a matter, see, there are matters under the rules of
Yeah.
the entire cabinet.
Yes.
There are matters which go only to a particular minister.
This one goes only to the prime minister.
It goes only to the prime minister.
Now,
You're saying this-
they've said so. They've said so, that it goes only to the prime minister. But what I am saying is, once your lordship lays down that in order to ensure the neutrality and independence of the election commission, which is essential for free and fair elections, which is part of the basic structure of the constitution, which is part of the constitution and indeed part of the basic structure of the constitution, then the selection of the election commissioners cannot be merely in the hands of the government.
There,
And
we
to
are-
the extent-
there we would like to ask you one more question.
Yes,
What will those two which will really go substantially
yes,
question at that. You want somebody to be appointed who will turn out to be the best man, the most independent man,
yes,
man of integrity.
yes,
Now, let us say that we accept your proposal. We
Yes.
say the chief justice will also be a party.
Chief Justice and the leader of opposition, like,
They will look it up.
yes,
Now, unless we also go ahead and say,
yes.
what are the qualifications? Who will make it to the panel? Will there be a panel of, what will be the number of persons who will be considered?
So,
The executive will prepare a panel. And if the chief justice goes there, it might be a one-day affair, a half-an-hour affair. He goes through the papers. We say, okay, the ACR of all these civil servants, they are outstanding. All are outstanding. So from out of them, how do you select them? Okay, seniority is one criteria. Take the name of that man. There's nothing against him.
so my respectful
What
submission.
we are saying is that whether on the ground this is going to produce results.
Yes, my lord,
what we are
I-
really concerned with.
I agree, and that's why, my lord, I have said, I have pointed out that in the case of the Information Commission, this court has laid down several safeguards. One is, they have said that, of course, the Act says there is a qualification criteria under the CVC Act and under the Information Commission Act, RTI Act. And there the qualifications are mentioned, all kinds of people, not merely civil servants. And in fact, this court remarked that you have been choosing only civil servants, when there are so many other categories of people who can be appointed, who are eligible to be appointed. Why don't you consider those? Why don't you ask for applications? And now they have started asking for applications, and about 500 and so applications come. And from that, my lord, there is a search committee which was also directed by the court. The search committee makes a short list. That short list made by the search committee and the criteria prepared by the search committee is supposed to be put out on a website. That's the transparency. I have mentioned all that. If your lordship just comes,
We'll go through that.
we've given.
You're commenting that. So
Even-
fundamental issue is going to be finally whether there is a vacuum.
Yes. So there is
Without
a vacuum.
How do we step in?
Yes, my lord. The vacuum can be seen in many ways. One is, when Parliament was supposed to make a law to provide for the procedure, etc., and no law has been made, obviously there is a vacuum.
So if that is so, there are many provisions in the Constitution
Yes.
which contemplates making of a law by Parliament.
Yeah.
In all these cases, will this become a precedent
No.
on the basis of which we can come to court, everybody can come to court?
No. Not in all these cases. So that's related to the trigger. I say that there is trigger in the reports of these 5 bodies. Same thing happened in the police reforms case. In the Police Act, the appointment was made by the president of the DGP, etc. But this court said that, look, there are these 4 reports, starting with the Dharamvira committee, etc., which have been saying that, look, you need to make the police somewhat independent of the government in order to enforce the rule of law, because otherwise they act as instruments of the political executive. And therefore, in order to protect the rule of law, which is part of the basic structure of the Constitution, therefore we have to now make the following directions for police reforms, and they made fairly comprehensive 6 directions, not merely the appointment of the DGP. They also said appointment of the DGP shall be in this manner, that the Public Service Commission will prepare a panel of 3 names on this basis, and among those 3 names, the government can select one. So they made various directions about police complaints authorities, about police establishment boards, National Security Commission.
Police acts have been made. Police acts have been made subsequently or amended.
Yes, some of those acts, my lord, have been stayed by this court by pointing out that they are inconsistent with the basis on which these directions were issued.
Can we equate that with the appointment of a constitutional authority?
In my respectful submission,
Is it not different?
my lord, that is not
Whether it should
different.
be viewed differently.
In my respectful submission, there is no difference, because
They are only asking.
yes, my lord, in my respectful submission, if there is a vacuum in the Constitution itself, suppose, my lord, the word subject to a law made by Parliament was not there. Suppose that was not there, original act was there. Dr. Ambedkar introduced that subject thinking that Parliament will make a law to provide for the procedure, etc. Unfortunately, that has not happened. One way of looking at the vacuum is that it is a vacuum created by the non-making of any law by Parliament. The other way of looking at the vacuum is, suppose this word was not there, subject to any law made by Parliament, and the original Constitution just said that the Election Commission shall be appointed by the President. Even then, in my respectful submission, there would be a vacuum, because mere fact that the election commissioner will be appointed by the president does not mean that the executive will not lay down a procedure for the selection of these election commissioners. even then there would be a gap in the constitution. It would be a gap which can be directed to be filled
All right.
if that gap has the consequence of violating either fundamental rights or violating or leading to the violation of any basic feature of the constitution, etc. And I respectfully submit that in this case, all those elements are there.
All right.
And we are being asked today by the Solicitor General to put the clock back and for the court to say, no, this untrammeled power has been given to the executive, and therefore, if the court makes any directions regarding this, then it will violate the principle of separation of powers. Lord, this bridge we have crossed long time back from Vishaka onwards, we have crossed it long time back. In all these cases, after the directions of the court, whether it's the whistleblower case or the
They
sexual
come out with laws.
no, first they came about with administrative notifications, putting in place a mechanism. The laws came sometimes 10, 12 years later. First, the government, because the court said that till the time that there is any law, these directions will hold the field. So they had to come out with a notification.
Correct.
So therefore, my lord, in all these cases, this happened. And even in the street vendors case, it was this court which said that, look, street vendors have some rights. You can't deal with street vendors like this. And that's why eventually that Street Vendors Act came. They have some fundamental rights. A system where there is no procedure of qualification laid down for the purpose of selection is incompatible with Article 14 of the
We'll go
Constitution.
through it. You kindly give us a note for whatever you have to.
Yes, Lord, I have handed over this.
That we will go through it. Then if this is
Achha,
what
all
we
right.
have to- Yes, please.
And I just wanted to point out that this latest appointment of Mr. Arun Goel, this has been made by giving him voluntary retirement. Thursday, your lordship heard the argument. Friday, he was a secretary in the government, sitting secretary. Otherwise, my lord, all the people, virtually everybody who has been appointed were retired people. He was a sitting secretary, given voluntary retirement on Friday. And his appointment order apparently is issued on Saturday or Sunday. And he starts working from Monday. So Thursday, your lordship heard this case where I mentioned that there is one vacancy and I'm seeking interim orders in this case. So what process, what procedure? In one day, you rush through his voluntary VRS, you give him VRS in one day.
See, VRS can be usually given only after 3-month notice.
Yes.
Under the rules, he must have given a 3-month notice.
I doubt it. I doubt
Unless they waive it. I don't know whether they can waive it.
I doubt it very much.
Normally, they have to give a 3-month notice.
That's why I'm saying that your lordship should ask for the records of this appointment.